So I'm Grace Thomas-Edmond. I'm a principal here at AJ Park and I head up our commercial team here. So one of the things we deal with a lot is confidentiality and NDAs. And this is really intended to be, I guess, a bit of an overview of how to protect your confidential information and some of the tricky issues with NDAs, pitfalls, and also covering a few frequently asked questions that we get about them. But if you do want to ask other questions, you can always put those through the Q&A function and we'll have a bit of time at the end to cover those off. Right. So that's kind of just a very brief overview of what we're going to cover today. So what is, I guess, starting at the very beginning, what is confidential information? I mean, it can include many different things and for each business or person, it's going to be different, but it can include trade secrets, other know-how, financial information, personal information. So if you've got employees, their personal information, or customers, data, other market sensitive information, and on a more IP side, invention information before you filed a patent or a design, and anything else that is information that has some value to your business and is not, generally known to the public. So how do you protect it? And I think if you think about protecting it, you probably think of legal obligations and keeping it secret and all those sorts of things. But I think the first step is actually to say, what is it? What information does my business or what information do I have that is confidential and valuable? Because if you don't actually identify what that information is, you can't protect it. And I think that's often how confidential information gets lost, is because it didn't get accurately identified in the first place. And I like to think about three categories of information. So there'd be information that is confidential, but you're not that worried about it, and you would disclose that to people even without an NDA in place. And that might include, some of your marketing information or information about your business that doesn't need that legal protection. Then you've got information that you would disclose under an NDA or another binding confidentiality obligation. And then you've got a third category that, again, I think is something people don't necessarily think about, but that is information that you wouldn't actually disclose to anyone, even under an NDA, or you might only disclose to a very narrow group of people or in very narrow circumstances, even under an NDA. And that might be, if you had some very valuable trade secrets, for example, you wouldn't just disclose those to anyone just because you had an NDA in place. You actually wouldn't disclose those potentially to anyone except for maybe a few key employees. And I think it's a good practice to have an idea of what information is in those three categories, and then obviously that's something that you would have to keep updated from time to time, because what information you hold and how valuable it is will change over time. So then the second step is actually protecting it. And I think there's two sides to that. One is a practical one of actually keeping it secret. So, making sure that from a practical perspective, people can't see it. So that might be, if you have a factory and the factory displays some of your trade secrets, limiting access to the factory. If it's more, digital information, then having those controls on people's computers, and so they can't actually access it and can't share it outside of your organization. And then legal protection, which is only disclosing it under contractually binding confidentiality obligations, which might be a specific confidentiality agreement or non-disclosure agreement, or it could be, confidentiality obligations in some other kind of agreement, like a services agreement or a supply agreement, or most contracts have some kind of confidentiality provisions in them. So just some more examples, I guess, of practical protection. I think staff training, especially if you have lots of staff, making sure that they understand what confidential information they have access to and what they can and can't do with it, and making sure that they have regular reminders about that. exit processes and interviews with staff that leave to reinforce those obligations, that they're not taking that information with them and using it in ways that they shouldn't. I already mentioned restricting access to premises and within systems. And then the other one, I guess, especially if you have a business that has a lot of trade secrets, having a clear process for disclosures. So if you've got your, what is the information we want to protect, but then also, you know, who can disclose it, who has to approve those disclosures, so that it's not happening on an ad hoc basis. You don't have, you know, some employee, you know, agreeing to a disclosure without going through an appropriate process and having sign off at an appropriate level, especially if you're talking about really valuable trade secrets. So I was just going to get, so this is getting more, I guess, into NDAs. So NDA is a non-disclosure agreement or a confidentiality agreement. And that's an agreement you would use to protect that confidentiality, especially in a situation where you might not have another agreement. So say you're having early stage discussions with a potential partner or a potential supplier or a potential customer, and you don't yet have any other contract in place. You would generally, if you're going to disclose confidential information, you want to put in place an NDA or a confidentiality agreement. And then I was just going to go through some of the key things, some of the key parts of an NDA and what they mean. And as I do that, I'll sort of point out some of the pitfalls, I guess, of some of these provisions. So I've picked this up from our standard definition of confidential information in the form of NDA that we usually use. So all information about the disclosure and its businesses, products and technologies. So that's pretty broad. We cover confidential information with it, whether it's tangible or not. So sometimes if you have someone who's drafting a more narrow NDA, they'll limit it to information that is disclosed in writing. And that would mean that you weren't covering anything that was disclosed orally. So that's one thing to look out for. If you're thinking, you know, if you're doing all your communication by email, that might be fine. But if you're having conversations with someone where you might be disclosing information, then you want to make sure that's covered by your NDA. And we say it's irrespective of whether it's marked or identified as owned by the disclosure or under the discloser's control. So again, some NDAs that might be a bit more narrow would say they're only going to protect information that is marked as confidential or marked as the property of the disclosure. And that means that we have to make sure, as if you were the discloser, that you are marking each piece of information as confidential or as protected by the NDA when you were disclosing it. And that gives you a much narrower scope of protection. And then we also say under 3 there that it covers stuff obtained before you sign the NDA. So if you've already had some discussions, you might be able to, you could protect that information even though you've already disclosed it. And then we capture notes, records, or copies of such information. So if you're having an oral conversation, but someone's making notes of it, then that becomes your confidential information. Or they're making copies of it, then those would be protected. And we usually cover the fact that discussions are taking place between the parties. So that's only appropriate for kind of sort of an early stage relationship. But often you don't even want anyone to know that you're talking to this other party until an appropriate time. Like if you take the example of some kind of transaction, you don't want the fact that you might be going to do that transaction getting out before you've, you know, it's certain. So we would cover the fact that the parties are actually talking to each other about whatever the subject matter is. So some common issues, I think I've already probably covered off most of these in talking through that previous slide. The last one is confidential information only protected if it's actively disclosed by one party to another party. So sometimes in an NDA, it would say that confidential information is information that party A discloses to party B. But sometimes someone might obtain information in a more sort of amorphous way than that. Like say they visit your factory and they see something and you would want that to be protected, but you're not actively disclosing it to someone else. So that's why our standard definition is all information about the disclosure and its business. It doesn't have sort of a step of the person having to disclose it to the other person in order for it to be protected. And then the final bullet point I think is important, which is that if there is a specific type of information that you want to be protected or that you're intending to disclose, it's better to just say that in your definition. You know, you can have a very broad definition, but say, and it includes X, Y, Z. Because sometimes you find the parties have signed an NDA and they did know what kind of information they were talking about, but they haven't called it out. And then down the track, it can actually be hard to say whether it's covered or not. An example that I had recently of that was a business who really wanted the identity of their supplier to remain confidential. And they had an NDA in place, but it didn't clearly cover, you know, the fact of that relationship as confidential information. But that was actually really important to my client, and it hadn't been called out. So I think if you have it in mind when you enter into the NDA, it's better to just list those things as confidential information if you can, in a non-exclusive sort of way. So it's, you know, it covers all your other information, but it includes these particular things. So then you have sort of standard exclusions from cover. And you'll see these in most NDAs. So information that the recipient already has usually wouldn't be covered, subject to that point about sometimes covering stuff that was disclosed before you entered into the NDA. But if they have it otherwise from some other source, then that wouldn't be covered. And that's covered also by that second one there, independently acquired or developed by the recipient without using the confidential information, is disclosed to the recipient by another person who didn't make that disclosure in breach of some other confidentiality obligations, or is or generally becomes available to the public. And usually we like to say that the recipient has to prove that the exception applies, because sometimes it can be quite hard. Like if they are saying, well, we already knew that, but you told us that, but we already knew it anyway. How do you prove that? So putting the burden of proof on the recipient is quite good, because then they have to show some evidence that they did actually already know it, or that they've received it independently. Because otherwise it's a bit of you can end up in a bit of a he said, she said type situation, which doesn't really benefit you if you're trying to protect your confidential information. The other one that I haven't mentioned there is, I might mention it later, but I'll say it now anyway. Is disclosures required by law. So usually you'd say if it's a disclosure that is required by law, say because of some kind of court proceeding or you know, some sort of regulatory process where you have to disclose information, then that wouldn't be a breach of the NDA, because it's not really fair to put any party in a position where they can't comply with their legal obligations. And sometimes that extends to disclosures required under the laws of stock exchanges. Like if one party is a listed company and they have stock exchange disclosure obligations. So what is prohibited under an NDA? So usually it's disclosure of the confidential information, which seems sort of obvious, except to certain people, or that exception about law, but also the use of the confidential information other than for the purpose. So sometimes you do come across NDAs that only prohibit disclosure, but they don't also prohibit use, which is actually really important, because you also often, you don't want the recipient using the information internally for some purpose that's not the purpose you gave it to them for. So say you were giving confidential information about your products to a potential customer or a competitor, you wouldn't want them to be able to go and use that to make a competing product, for example, when they were meant to be using it to decide whether or not to buy products from you. So the use one it's important to have that covered as well. And you do sometimes see NDAs that only prohibit disclosure and not use. What other things do you see in an NDA? So you should make sure that, so usually a recipient will be allowed to disclose the information to, say, its employees or its directors or its contractors or sometimes related entities, but they should be required to make sure that any person they do disclose information to is bound by equally stringent, legally binding obligations of confidentiality and non-use. Sometimes you see restrictions on copying information. It's not always very practical to say, you know, some NDAs say you can't copy the information at all, which I've always thought is a bit impractical, especially if you're thinking about, like, say, I get an email with some confidential information into it and then I save that into my document management system. Well, technically I've copied that information. So I think in ours we say you won't copy it except as strictly needed for the purpose for which you've received it. So it's a bit more permissive, but sometimes you see ones that have a complete prohibition on copying any confidential information. Sometimes you see specific security requirements around how you'll keep that information safe. Usually you'd have an obligation to return or destroy the confidential information on request and or at the end of the term of the NDA, and that's quite important. And it's good to have the ability to request return or destruction at any time, rather than having to wait until the end of the term. Let's say the NDA has a term of 1 year or 2 years, but you might decide 6 months in that you don't want to go any further and you want to ask them to return or destroy all your confidential information at that point. And you'll often say they have to certify that they've done that. And you also often have an obligation for the disclosure, for the recipient to notify the disclosure if they've become aware of a breach of the confidentiality agreement and take action to remedy that breach, which, I mean, I'm not sure if it gets complied with very much, but it's good to have that in there because in some cases you wouldn't know that there'd been a breach because it might be internal or something you don't have visibility of. You often see a clause saying that the disclosure can get injunctive relief. So, you know, an injunction against disclosure if you think there's going to be a breach or there's going to be further disclosure in breach of the confidentiality agreement, that gives you, you know, a bit more of a chance of getting an injunction against that. You also often see a statement that the disclosure is not giving any warranties about the information. So usually you're at kind of an early stage in the relationship. You don't want to be giving warranties about accuracy of information. You know, you might do that later. If it's a transaction, you might give warranties when the transaction actually happens. But otherwise, you don't want to be giving those warranties, especially at the stage where there isn't any consideration flowing for those warranties. Or, you know, usually there's no money changing hands or anything. You're just having preliminary discussions of some kind. So what about IP ownership? And one of the frequently asked questions is around this, but, you know, a standard NDA actually doesn't say anything about IP, or it might just say there's no transfer or licensing of IP under this NDA. So it's making it clear that we're not transferring any ownership in anything by giving you the confidential information. We're not granting you a license, but that's all. In our standard one, we go a little bit further than that, sometimes where it's appropriate, and say that the disclosure will own any improvements that the recipient makes to the confidential information. So if they come up with an idea that's a tweak to your confidential information, then the disclosure would own that. That's not always going to be appropriate, but if you are the disclosure, it can be quite a good starting point to have that in there. But it wouldn't be standard and it wouldn't be in most NDAs. How long do NDA obligations last? So there's kind of two different terms in an NDA. So there's the term of the actual agreement. So, and it would cover disclosures or information received during that term. So that might be 1 year. It might be until someone terminates it. So often you would have one that just kept going, but either party could terminate on 30 days notice, and then disclosures made during that time are protected. But the obligations of confidentiality that protect that information will usually last longer.
So we would usually say they last until the information enters the public domain. So, the information is protected for as long as it is confidential. Now, I'm not a US lawyer, but my understanding is that in some states in the US, they won't enforce perpetual confidentiality obligations, except in relation to trade secrets. So if you see an NDA coming out of the US, it usually has a time limit on obligations of confidentiality. It's often between 3 and 5 years. Sometimes that will be, they'll sort of make a distinction between trade secrets and confidential information. So they'll say the protection for trade secrets lasts until that information becomes public, but for any confidential information that's not a trade secret, it only lasts that sort of 3 to 5 years, whatever you land on. And my understanding is that's because in some states in the US, you wouldn't be able to enforce that perpetual confidentiality obligation on non-trade secrets. And that's pretty standard. And if you think about it, for a lot of confidential information, 3 to 5 years, the information's probably not, like if you disclose it and then 3 years later, is it still going to be valuable? Does it still need that protection? Sometimes it will, especially if it is in that category of sort of very valuable trade secrets, but not necessarily, especially, confidential information often evolves and is iterative, so it does lose its value over time. Is your NDA binding? So it's good to make sure you're getting them signed by the right people. And again, we had one question come through about that. Generally, the signing requirements depend on where the person is resident or incorporated. So, for a New Zealand company, you usually need it to be signed by an authorized representative. Or if it's a person, they can just sign it. It's not a deed, so you generally need signing by deeds. Signing as a deed, sort of in front of witnesses or anything like that. But some countries do have specific requirements, and China's one that I'm aware of, where if it's a company in China, you generally want to get it signed under their company seal, and by, I think it's the legal representative is kind of the formal office of the person that you want to get to sign a contract. And other countries might have their own requirements as well. So it's good to check that. It's also good to check, I think, if you're dealing with a big company, it's probably worth asking that they get it signed by the right person and not by someone who doesn't really have authority to sign it, because otherwise you could end up in a fight later on. It's also, you want your NDA, if you're dealing with a company, the NDA really needs to be with the company, not with the individual person you're dealing with. Same goes for universities. I think sometimes you see sort of research staff receiving information and I don't think they're trying to be sneaky, but receiving it in their personal capacity and signing in their own name, whereas really you want if they're receiving it as an employee of the university, then the university needs to be bound by the NDA, not the particular researcher that you're dealing with. Governing law and dispute resolution is often one that comes up, especially when you're talking about, a cross-border situation. So you often end up in a bit of a fight about where it's going to be. If you're dealing with an American company, they'll inevitably want it to be New York law or the law of whatever state they're based in. We often try to go for something neutral if there's going to be a dispute about it. Something like English law or Singapore law. In China's got its own special requirements because you can't enforce foreign judgments in China. So if you got a New Zealand court judgment, my understanding is you're just not going to be able to get that enforced against a Chinese entity in China. So you either want to go with enforcement under Chinese law in China, and it's probably the more popular option is foreign arbitration, because it's much easier to enforce a foreign arbitral award than it is to enforce a foreign judgment. So we would often go with like the laws of England and Wales and arbitration in Hong Kong or Singapore.
or even Singaporean law and arbitration in Singapore. The good thing about doing arbitration in either of those places is that you can get a decision in Mandarin, and so then that's a lot easier to enforce in China if you're going to do that. Also, to enforce in China, you're going to need your NDA to actually be translated into, translated into Mandarin Chinese as well, so that you can put it before the Chinese courts. So I was just going to flick through. So we did get some frequently asked questions come through. So I was going to flick through these, and then I'll go through the Q&A. I've seen a few questions have come through there, so we'll go through those. One was, what's the difference between an NDA and a confidentiality agreement? I think this is one where they're just two names for the same thing. Some people might think there's a distinction, but in my mind, those are used interchangeably. And what really matters is the exact terms of whatever document you've got in front of you, not what it's called. The one that is a bit different is one that's called an NNN, which you see used in China, and that's a non-disclosure, non-use, and non-circumvention agreement. So the standard NDA would cover non-disclosure and non-use, but non-circumvention is really about, if you think about a Chinese supplier, manufacturer supplying to another company, saying that that supplier won't go around you and try and get to your customers directly. So they're not going to try and circumvent you in the supply chain. And sometimes they've got a few other terms in there, those NNNs, sort of non-competition type, or even sort of restraint type terms, exclusivity type terms. So they're a bit more substantive than a NDA, and you see them a lot in China. I think I've also seen them coming out of India. I can get a free NDA off the internet, so why should I pay to have one prepared? Look, it's all about your risk appetite. I think you know, I mean, I've talked about a lot of the kind of ins and outs of an NDA, and we do always tailor them for the specific client and the specific situation that you're using them for. You absolutely can get one off the internet. It'll get you 90% of the way there. But if you do have some information that you really want to make sure is protected, you know, and it's really valuable, it probably is worth having one amended so that it is specific to your situation. But lots of people use ones off the internet and presumably most of the time don't have a problem, but then sometimes they do, and they come to me and I say, yeah, this could have been drafted better. So, you know, it's about your risk appetite, I think, and how valuable that information is to your business. How do I get an NDA signed in China? Is it even worth trying? And what else should I be doing to ensure confidentiality obligations are honoured? Look, I think China, I mean, obviously it's got a bit of a bad rap when it comes to IP and confidentiality. I think it's getting a lot better. I touched on some of the stuff before, but have a document that is actually in Chinese or in Mandarin. Consider that dispute resolution and governing law question quite carefully. I think outside of getting an NDA signed, the thing I get here the most is doing your due diligence and making sure you're dealing with, you know, a really reputable operator in China. I think there are some, you know, bigger, more established businesses over there that really are trying to operate in a, you know, in a genuine and respectful way around this stuff. So, I mean, I think NZTE help with some of that, or get a recommendation from someone you know who does business in China. Make sure you're dealing with the actual, you know, like, make sure you're actually dealing with the entity you think you're dealing with, and check, you know, that you're using their proper registered company name and that you're getting the proper person to sign the documents and those sorts of things. They can always help you. But I mean, yeah, and that's not to say it's not without risk. I think it's a market where there is more risk, but I do think it's getting better. The other thing you can do from a practical perspective, I think, is thinking about what information you're disclosing. So one thing I've seen people do if they are getting some manufacturing done in China is, can they make sure that they're only giving the Chinese manufacturer some of the information that you need to make the whole product? because if they don't have all the information, then they can't make the whole product and sort of sell it off on the side, or something like that. So that's one thing to think about. Can you get just parts manufactured by different people so that you're not putting the whole product at risk? People who don't want to sign NDAs. What do you do? Well, I mean, the main thing I would do in that situation is try and figure out what information can you disclose when you don't have an NDA, and there might be some information that you don't mind disclosing. And if you think about it as stages, like maybe they don't want to sign an NDA now, but if you disclose a certain amount, you get them interested enough, then they might sign an NDA in order to proceed. So yeah, I mean, again, it's a risk question about what are you willing to put at risk in order to maybe make an investment or a deal with a big multinational company go ahead. But there's no magic solution to that one. I'm not quite sure what an anti-NDA is, but it's probably just something saying that, you know, whatever information you give us, we can use it without impunity, with impunity. So, I mean, try not to sign that sort of thing. But sometimes it might be worth it. You might make the decision that that is worth it because the potential deal is worth it. Who should sign NDAs on behalf of a company? So, I mean, I touched on this earlier. There's no magic to it. I mean, in New Zealand, I mean, any authorised signatory can sign. If you're worried about authority, I would try and get it signed by a director, because that's just going to give you a bit more to hang your hat on in terms of that sort of implied authority to sign. If you're thinking about overseas entities, I'd probably be a bit more careful and try and do a bit of research into who can sign on behalf of whatever kind of entity you're dealing with. And especially where you're dealing with a big company, you don't want it to be signed by someone who's, you know, well down the food chain of authority, or ask them to show that they have that authority to sign. You can always do that. So I think this is a common misconception, is that NDAs generally don't deal with IP ownership, as I was saying. So, I mean, I would always say an NDA is really for where you're sharing information, and it's sort of a preliminary agreement. If someone is creating things for you, you know, they're writing software for you, they're creating marketing materials for you, they're creating prototypes for you, I would want a more fulsome agreement than an NDA that did deal with IP ownership, because an NDA, that's not really what it's designed for. So I think whenever anyone is creating something for you, you should have, whether it's a services agreement or a commissioning agreement or a supply agreement, that deals with IP ownership in it, because that's not really what an NDA is for. How long does an NDA last? So you can have them last perpetually. You know, often we'd say they last perpetually, but either party can terminate on a certain amount of notice. Do you need a new NDA for each part? So not necessarily. The reason you might want to is that an NDA would usually say, you can use and disclose this information for this purpose, and it would define what that purpose is. And so your NDA might become irrelevant or not quite fit for purpose if you've moved on to a different purpose. So say you have an NDA that says you can use or disclose this information for the purpose of the parties discussing a business relationship. That's fine, but then once you get into the actual business relationship, that sort of isn't the right purpose anymore. So then you might need a new one, or it becomes superseded by some other agreement relating to that relationship, like a supply agreement or a services agreement that has its own confidentiality obligations in it. So I mean, yeah, so some NDAs are limited and like have a limited term, like 1 year, 2 years. So with those, you just need to be careful that you haven't let it expire, but you're still trying to rely on it. And so some method of keeping track of that or checking in on that is good. So that was all the ones that came through sort of separately. And then I think, Anna, were you going to read out some of the other ones that have come through while we were going? I think we've got about 10 more minutes.
Yeah, sure. So one's come through in an R&D context. we often see an NDA usually mutually prepared to capture ideas. Do you foresee an issue with this?
So the capturing ideas part. I think capturing ideas can be confidential information as long as they're not publicly available and they're not being disclosed. So I don't think there's a problem with that. Sorry, I might not be answering the exact question. I'm not quite sure.
Cool. Next question was, can you elaborate on the signing requirements in China? So, yeah.
So I'm not a Chinese lawyer, obviously, but my understanding is that, well, yeah, is that so unlike New Zealand companies, which have mostly got rid of their seals, that Chinese companies have seals, and they often have many different ones for different purposes. But I believe they usually have one that's called a common seal, and you want that one to be on your document, and then you want it signed by the person who is the legal representative of the company. I think, obviously that's the English term. I think that's the right term. And I think that information is publicly available, probably only to someone who speaks Chinese, but I think you can check on the company's register that who the legal representative is, and then that person has authority to sign. There might be other ways, but those are the ones that I've sort of come across. I'm not an expert, but that's what I've been advised is the best way to do it. The other thing that's really important, I think, if you're dealing with a Chinese company, it's not really a signing requirement, it's just to make sure that you have the name of the company right. Often, I think you find with Chinese companies, they can be often they have lots of different forms of their name. I'm not sure exactly why, but making sure you have the actual registered name of the company and that you have it in both the English and in the Chinese characters. Because otherwise there can be some confusion about the actual entity that you have contracted with. So I think that's quite important as well.
Cool. And why is it good to have the organisation sign the NDA rather than the individual?
Because if you think about an employee, you're not, like if you were dealing with a person in their individual capacity, that would be fine, but you're dealing with them as an employee of their organization, and they'll have obligations to their employer and, or potentially professional obligations that would apply to that confidential information. They can't really receive it as part of their job. You'd be putting them in a position of conflict where they would have this obligation to you, but then also potentially these obligations. I just think, in fact, you are disclosing it to the organization if you are dealing with them in that capacity, and because it will probably be saved into their computer system or stored on their premises or whatever, you want that entity to be bound, because having a cause of action against the individual is probably not going to get you very far. It's a bit like you wouldn't have an agreement with me personally for me to provide the legal services because they're being provided on behalf of AJ Park as the law firm. I think it's a bit the same, maybe in reverse, is that you're actually dealing with the entity, not with the individual.
Cool. And how have the courts treated claims of NDA breaches? In addition to injunction relief, are damages usually awarded, or are damages generally too remote or indirect?
That's a good question that I don't really know the answer to. I'll be honest that you don't see them enforced that much. Especially in New Zealand. I'm sure if you went through the case law in America, for example, you'd come up with many examples, but I think in New Zealand, they mostly serve a deterrent purpose in that you get someone to sign it, and then, it's really there to get them to comply, because once they've released the information, it's kind of too late. So I haven't actually been involved in any cases where people have enforced them. I've been involved in cases where people have, enforced them in an informal sense, where you sort of write a letter and ask the other side to do something, like maybe they take down a social media post or they try and retract some information, although that's pretty hard, especially if it's done on the internet. But I think they're mostly about deterrence. Sorry, it's probably not the most helpful answer to that question. I'm sure you can claim damages, but I think you're right. How would you
figure out what they were, it will be difficult. So you're much better off having the obligations in place and then, you know, reminding people that they have those obligations and getting them to comply with them, rather than trying to sort of pursue legal remedies after the fact.
And this is sort of quite similar to the previous, but how often do you deal with breaches of NDAs which cause the disclosure to suffer loss?
Yeah, I mean, not that often. I mean, I had that one recently, which was sort of a supplier had released some information about one of their customers that they didn't want released. And that was sort of that situation where you wrote a letter and got some stuff taken down off the internet and got them to promise not to do it again. It doesn't happen that often, which is sort of surprising. Maybe it means the NDA is doing its job and people aren't breaching. Or, I mean, I'm sure in a lot of cases there are minor breaches that no one ever finds out about. But no, I mean, it doesn't happen as often as you might think, given the number of NDAs that people seem to sign.
And this is to do with, I guess, NDAs across jurisdictions, but what's the difference between governing law and jurisdiction clauses? How should a New Zealand company approach drafting or negotiating these clauses when dealing with US suppliers?
Yeah, it's tricky. And especially, I think, you know, getting someone in the US to agree to New Zealand governing law or New Zealand jurisdiction is quite hard. So the difference, so governing law is the law that governs the interpretation of the contract. So if you come down to what does the contract mean in a dispute, what does this particular part allow me to do or not allow me to do? You know, there are rules of interpretation that apply to that, and that's what governing law provides essentially. So jurisdiction is where can you bring a claim against the other party. And that can be either exclusive or non-exclusive. So you can say, you know, New Zealand law and the non-exclusive jurisdiction of the New Zealand courts. So that means you definitely can bring an action in a New Zealand court, but you also potentially could bring a claim in another court that had jurisdiction for another reason, for example, because the other party was based in that country. Or you can have exclusive jurisdiction, which is the parties have agreed that this is the only place where they will bring an action. So, and they don't have to be the same. So I think I gave an example of having governing law of England and Wales, but have, say, arbitration in Hong Kong. If you split them, I mean, arbitration is sort of a slightly different beast, but if you split, like if you had the laws of England and Wales, but jurisdiction in New Zealand, you can do that, but it means you have to adduce evidence in the New Zealand court as to what the laws of England and Wales are, because the judges in New Zealand are sort of deemed to know all the New Zealand laws, whether or not that may be true, but they aren't deemed to have any inherent knowledge of what the laws of any other country are. So you would have to adduce evidence of what those laws were so that the New Zealand court could then apply those laws. The approach you should take as a New Zealand company. Look, it is a tricky one. I mean, we often start with New Zealand law and New Zealand jurisdiction, but you know, often that would get rejected. You can go for something neutral. So I think I mentioned, you know, like Singapore law and arbitration in Singapore. You know, if you're thinking about the US, that's roughly geographically in between the US and New Zealand. It doesn't favor either party. If you are going to go with one of the US laws, some are more standard than others. I mean, I'm not an expert on US law, but I think, you know, laws of New York or laws of Delaware, you know, those are big commercial hubs that have relatively internationally standard laws, rather than say, and I don't want to malign any states, but say, I don't know, the laws of Utah, like I've just got no idea. So that's often an approach that we have taken, with the caveat that I think that, you know, dispute resolution in New York is bound to be incredibly expensive. So that's something to think about as well. I think the other thing to think about, and this isn't really, I don't know if this is legal advice, but is, are you ever going to take them to court? Like, I've definitely had clients in New Zealand who are like, well, we are never going to sue them. So what we want to stop is them suing us in New York, because that would be really expensive. So you take an approach based on, where do we want to be sued? What can we live with on that side, given that we're probably never going to end up in court over this? You know, we're never going to instigate that because we're a small company, or we're, you know, a government related entity, or so you can be a bit pragmatic about it. And I think that applies well to NDAs where, you know, are you ever going to sue them for breach of the NDA? Maybe you are. It very much depends on what sort of business you're talking about. But if it's got a more of a deterrent purpose, then maybe you can compromise more on the governing or jurisdiction side of things.
Right. And I'm conscious we're at 12:45, but there is one more, which hopefully is a quick answer. So how have you seen liquidated damages for breach agreed in an NDA?
I have seen them in there. I've never seen them applied. We did one relatively recently where it was specifically for India, and we got some Indian law advice, and they recommended putting liquidated damages in the NDA. It's not very common, I wouldn't say, in New Zealand or America or some of those places, but yeah, I mean, the Indian advice we got was to put liquidated damages in, and I believe that got accepted. They were quite high. You know, and in a New Zealand context, I probably would have said that might be an unenforceable penalty, but I think that, you know, the agreement was governed by Indian law, and the Indian law advice was that was acceptable and recommended. So, but it's not that common. I mean, yeah, so you would need to be careful that they were in some way they've changed the test recently, although they have in Australia, but, you know, a genuine pre-estimate of loss, so that you don't get stuck with it being an unenforceable penalty. But it's not particularly common. Yeah.
So that's it for the questions.
Okay, great. Well, I mean, if anyone does have more questions, you know, you feel free to email me. And yeah, hopefully that was useful. I feel like it was a bit of quite a lot of information, but hopefully useful hopefully everyone can take away sort of one tidbit or something. Great. Okay, well, have a nice rest of your day, everyone.